Great. So, welcome back to another episode of our podcast, and I'm delighted to be joined by the lovely Joanna Sutton. Joanna is an employment lawyer who works for Long-overdue. She's been there not shy of 9 years now, nearly 9 years, and she's volunteered to join us and talk to us about the Employment Rights Bill. So, welcome.
Thanks, Trish. Thanks for having me. The changes that are to come in the Employment Rights Bill are really quite far-reaching, and so it's really helpful as well from my point of view to chat them through with you and to see your take on them as well. So thanks for inviting me along.
Fire and rehire. So back in July, we had a code of practice. And now we've got something that's been included in this bill. So what's different, and what do employers need to be cautious of in terms of fire and rehire?
Well, I think the code of practice kind of came from the Conservative government. So, that's probably something, it was kind of a legacy left over from then. Essentially, fire and rehire is a practice where some employers, if you want to change an employment contract that is already in place, and you say to the employee, right, I need to change this, and you consult with the employee about it with the aim of getting them to agree. If they don't agree, then ultimately what an employer can do at the moment is to dismiss them and then offer to re-employ them on the new contract terms that they want them to accept. So fire and rehire them. And this has kind of been quite a controversial practice, perhaps becoming more controversial over the last few years. It's what happened in the P&O ferries situation not so long ago, which really kind of brought it to everybody's attention that this is something that happens. And so the code of practice was brought in really to regulate the practice of fire and rehire, to say that if you're going to do it, this is what you need to do and the steps that need to be taken. And these are the sort of reasonable actions that you should be taking. The Labour government do not like fire and rehire at all. And so basically what they're proposing to do is ban it altogether, so that you cannot treat somebody like that, So potentially huge change, because you're stuck with the employment contract that you offer someone on their first day of employment, or in that offer period, and it can't be changed unless the employee agrees. So it gives the employee a lot more power in these situations, whereas when you could fire and rehire them, they know the threat is that you could lose your job if you don't agree to this change. It makes it unlawful to do that, and an automatically unfair dismissal, which is quite serious. There's going to be a sort of relatively limited exception where an employer could do it basically if there's no alternative and their business is going to go under if they don't. And even then, there's still going to have to be quite extensive consultation and things like that's going to have to happen to be able to establish that defence. So, effectively banning that practice altogether. It's not something that happens, every day. It's not kind of a very widely used practice, but it's something that, certainly happens in. I've advised a number of clients in respect of it over the years. I expect you probably have as well. And it's one of those areas that has become less and less popular. It's quite controversial. It carries a lot of reputation risk, particularly, we will have all heard about all of the noise around the P&O thing, which also was just delivered terribly over a pre-recorded video call or something, I think, wasn't it? So, for some organisations, a big change in terms of just not being able to have that practice at all anymore, which, as I say, strengthens the rights of employees. And you may find that employees becoming a bit more resistant to any kind of change because they know that the balance of power is in their favour.
I suppose it's one that I definitely do agree with, because I always feel like whenever I'm advising on that kind of thing, it just never feels right, if I'm honest. And I know business isn't necessarily about what feels right, but that practice in particular just always feels icky, for want of a better word. So I'm glad it's going.
Absolutely. It's a real last resort, but it does also feel kind of quite, the balance of power is definitely all in favour of the employer. They're just saying, well, accept it, or we'll get rid of you and then replace you with somebody who will accept it. And, that's then encouraging worse employment law terms to be in place, because, you know, very often then it might be lower pay or worse conditions and things like that. So yeah, I agree that it seems to again be one of those changes that better reflects modern life, I think.
Mm. Alrighty, so moving on to dismissal following family leave. So we've been talking about how most of these changes are kind of strengthening the rights of employees, which is obviously, I guess, what you would expect. But with this one in particular, what kind of protections are people going to have if this part of the bill kind of goes forward and becomes law?
Yeah, I think this is another one where there's not a great deal of clarity around it. And, you know, reading through everything, I was kind of trying to piece stuff together and think, oh, actually, what is this saying? So the law changed where women gained additional rights in a redundancy situation throughout their pregnancy and upon their return to work. And that had previously just been, once you return from maternity leave, you have the right to be offered an alternative vacancy if one exists, rather than being made redundant, and extended that protection essentially from the moment you inform your employer that you are pregnant until up to 18 months after you've had the baby. So yeah, quite a long period of time. What, as I understand it, this is proposing is to extend that right so that it doesn't just apply in a redundancy situation. So it would apply to a termination of employment for any reason. So perhaps poor performance, something like that, that there's this additional protection that you have where up to 6 months after you return to work, you can't be dismissed for any reason when you've returned from maternity leave or other types of family leave. So it includes adoption leave and shared parental leave as well. So again, is meant to sort of extend the protection afforded. And that's really on the back of, you know, campaigning that various organisations have been having, where I think the stat is 54,000 women a year leave the workforce after they've had a family, after they've had a baby, for, you know, redundancy or whatever reason. And so it's really meant to kind of build on those protections being available. So yeah, an interesting one, but not entirely sure how that's going to operate in practice, because obviously redundancy is one thing, but if somebody is returning to work and commits misconduct or something like that, it doesn't seem to be quite right that they would then not be able to be dismissed for it, you know, if there was something sufficiently serious. So I think there's going to have to be a lot more flesh on the bones on that one to see how it will actually work in practice.
That feels like quite a big one, to be honest. I know we
Yeah,
talked about dismissal and the impact of that, but
yeah.
actually this has potential to be quite a big change, to have a big impact on employers.
Yeah, definitely. And it seems strange. I was trying to read to see if it does just apply to women, and it seems to be, but you would think that, you know, with some of the other types of leave that are available now, like shared parental leave, or perhaps a
Mm.
man taking an adoption leave, or in a same-sex relationship and things like that, it's not just women who are impacted by this potentially, but it seems to be everything I've read refers to women rather than it being applicable to anyone returning from kind of an extended family leave period, which seems to be a bit of a missed opportunity, I think.
Yeah. Definitely one to watch, I would
Yeah,
say.
absolutely.
Yeah. Alrighty. That probably segues us quite nicely into the kind of diversity related changes that are within the bill. So that, I guess the one thing I picked up on, which seemed quite new, is the need for menopause action plans.
Hmm.
What are your thoughts on that? And I suppose my reaction to that was, oh, that's great, that's new. But would that be your reaction as well?
Yeah, I think we talked about this on our last podcast actually, about menopause and whether
We do.
policies and things like that should be in place, because I was starting to see that more and more organisations were expressing interest in that, or, you know, then feeling like there was more of a movement towards having to have more in place to support women at work, which, you know, absolutely great. But I think we've kind of said, yeah, policies are all very well, but you've got to live by them and not just have them as a nice to have. And I think the concern is that might be, this menopause action plan might become one of those types of things. So it's only going to apply to large employers for a start. So it's employers that have at least 250 employees. And it's kind of tied into gender pay gap reporting, because it hits that as well. It's not just a sort of standalone menopause action plan. It's an equality action plan, where essentially you're looking at, how are you going to close the gender pay gap in your business, and what else are you doing to support people within your business? And, you know, probably isn't going to just be limited to women. It will be, you know, limited to extended, to other types of groups within the workforce that need that protection for, you know, equality. So again, yeah, not much detail on this, where it sort of says, oh yes, and we're going to introduce equality action plans, and sort of, yeah, it will cover menopause and what you need to do to support women, but not much more detail. And again, only for those larger employers, which at the moment, when you are required to report gender pay, you know, that has to be on the website. So I would imagine that this will have to be something that is also documented and available on your website. And in the same way that there's kind of a growing interest in what an employer is doing, you know, to support local communities and, you know, social responsibility and stuff like that, I think that this will potentially be something that people would look at perhaps when they're looking at, you know, coming for an interview or something like that, to understand more about what your business does to, you know, to support and promote equality. So a good thing. But yeah, one of those that further consultation is going to happen, and we don't know exactly what that's going to say, and whether that, you know, the cynical part of me thinks they're just going to say, and it must include something to do with the menopause, and, you know, whether that's just going to be a paragraph, and, you know, that's going to go back to that point of policies aren't enough, you know, you've got to live them.
And if you want to listen back to the podcast that Joanna and I did, where we talked about it, it's all available on YouTube and all your favourite podcast channels. Because we did have a good conversation about it, didn't we? There was a particular case that we were talking about that was quite interesting. So if that is genuinely, if that's something that's of an interest, then have other recording. All right, so we talked about redundancy very briefly in relation to another part of the bill, but there is some specific information around collective redundancy, but particularly around establishment. I feel like this was the most like technical bit that I read, where I had to kind of reread it quite a few times to really understand what it meant. Given how awesome you are at simplifying things, how would you simplify that part of the bill for people who maybe aren't legally minded?
Well, I'll try. It's a complicated area anyway. So effectively, what the law says at the moment is that where you're making 20 or more redundancies within a 90-day period at one establishment, which is the key term that we're looking at, you have to engage in collective redundancy consultation, which has to last for a set amount of time. You have to do things like elect representatives to consult with and do certain things in that consultation process. But the at one establishment rule has been, again, quite controversial over the years. So effectively what that meant is, when you look at whether you're making 20 or more redundancies, you only have to look at one place of work. So the reason why that this has been, you know, sort of publicized is, again, another big company. It was Woolworths, when Woolworths went into administration, and in looking at whether they had complied with their duty to collectively consult with their staff when they were being made redundant, when the company was going under, it was decided that they only had to look per branch rather than across the whole business, whereas obviously across the whole business, there would be more than 20 redundancies happening at any one time in a 90-day period. And so everyone kind of, those decisions were made, but it never really quite sat right with everybody, because, you know, it doesn't really seem fair in those circumstances that you would just look at one branch of Woolworths rather than across the whole business. So what this change is proposing is to remove that at one establishment rule, so that if you are making 20 or more redundancies across your business within a 90-day period, the duty to collectively consult with employees will kick in. So that's the change, essentially, which I think is for the better. I mean, it's going to be more work for employers, obviously, but it seemed to be like a bit of a get out of jail free card when you used it. And when I was advising clients on it, it was one of those that didn't really feel right, where you would kind of go, oh, well, are they all working at the same place? Or, you know, and they sort of, you could do things if you're a bit, you know, being a bit tricky to sort of move people around so that the 20 people thing didn't kick in. So it's effectively removing that, which ideally is going to make it more straightforward. So if you're making 20 redundancies within a 90-day period, you're going to have to collectively consult with people, and that's essentially potentially the change. So should simplify things, but again, perhaps won't be popular from an employer point of view.
It feels like a fairer approach, to be honest. Do you know what I mean? Because, like you
Yeah,
said, you can jiggle things around, but if you're having to find ways to jiggle things around, it always feels a little bit like maybe we shouldn't be doing this.
yeah,
Let's try and be fair.
absolutely. Yeah, it's just a cleaner way of dealing with it, I think. So
Mm.
yes, it means it can be more onerous on an employer, but it's more straightforward, and you haven't got to look at too much of the technicalities, which is always helpful. At least from an HR perspective, that you you don't have to get into the minutiae of all the detail behind all of this. So yeah, should be more straightforward.
I'm all for helpful changes. Helpful changes are good. Alrighty, so again, we've kind of touched on this a little bit, but it would be good to just get into your brain a bit more in terms of this point. So sick pay. So there's quite a couple of changes, or maybe a couple more. You can tell me with your expertise, but there's some changes that the bill is proposing to introduce. Same questions as before, really. What are they, and what impact are they going to have on employers and individuals?
Yeah, so this change, again, is probably one that's going to impact all employers really initially. So at the moment, you only have to pay statutory sick pay to an employee. So that's kind of the minimum level of sick pay that you have to pay. You only have to pay it from day 4 of the absence. So effectively, the first 3 days that an employee is off sick are called waiting days, where you're basically waiting to see if they're going to come back to work and get better, if they're going to get better or if they're going to stay off sick. And so the law has said for years and years, first 3 days, you don't need to pay them anything at all, which, that's quite difficult from an employee point of view. If you're deciding, should I go to work or should I stay off sick, but I'm not going to get paid or have anything come in. And yes, some companies offer enhanced sick pay where you would get paid for those first 3 days, but many companies don't. And so what is changing under the Employment Rights Bill is that those waiting days are removed. So effectively, from the first day you're off sick, you're entitled to statutory sick pay. So it will bring a lot more people into scope of having the right to be paid for any time off sick, which, from an employer perspective is going to be more costly to the business and everything else. The other change that's being proposed is to abolish the need to be earning a certain amount of money before you qualify for statutory sick pay. So at the moment, it's only, I think, if you're earning at least £123 a week, that you're entitled to statutory sick pay. If you earn less than that, you don't get anything at all. Not, even after those waiting days, you just don't get paid, which again, terrible for people who are lower paid. And that's going to have more of an impact on them than it would, potentially someone who earns more money. So the Employment Rights Bill abolishes that so that there's no lower earnings rate that you need to qualify. But what they have said is that instead of paying the full rate of statutory sick pay, which I can't remember what it is at the moment, Trish, about £116 a week, something like that. It's not much.
It's always woefully inadequate, isn't it? But let me have a look whilst.
Yeah, so effectively, it's going to, for lower paid employees, you don't earn the full amount because you might be earning less than that anyway. But the government are going to consult on paying just a percentage of what you would normally earn during that period that you're off sick. So that's what the change is going to be. And so I said at the beginning that perhaps some of these changes are going to be able to go through more quickly than others, and because this is effectively sort of a bit more of a technical change rather than something that needs loads and loads of legislation drafted, this is something that might come in a bit quicker. And I think the rates are like 50%, 60%, 80%. What does everyone think about what the percentage should be? So yeah, one to watch. I think that might be one of the quickest developments that we see.
And for our listeners and people who are watching, the current rate at the time of recording for statutory sick pay is £116.74 for up to 28 weeks. But obviously, do make sure that you keep an eye on when you're listening and have a look on the government website to make sure that rate's correct. So sexual harassment then. So we've seen some changes in terms of some things that are coming in towards the end of October already, but there's a nod to this in the Employment Rights Bill as well. So what are we looking at here, and what do employers need to be thinking about in terms of these changes that are coming?
There's been quite a lot of confusion around exactly what those changes are. So employers have to take reasonable steps to prevent their employees from being sexually harassed. And there's a bit of confusion initially in the way that the legislation was worded about whether that just applied to that duty just being from your own staff, so that the people you employ can't sexually harass each other, or whether it applied to your clients and customers sexually harassing your staff as well. And it just hasn't been clear. The legislation says one thing, then there's been some guidance that has come out from the Human Rights Commission who've said other things, and so that's one thing. But the change that's being proposed under the Employment Rights Bill is to build on those protections that are about to be introduced. So what the Employment Rights Bill says is that employers must take all reasonable steps. So it's more onerous rather than just saying take reasonable steps. It's all reasonable steps. So more of like an exhaustive duty that you have to have done everything you can to stop your staff from being sexually harassed at work, which for some sectors, I've got friends that work as HRDs in like hospitality and things like that. That's a nightmare for an employer to comply with. Then it gets worse. The duty is going to be extended to third parties committing any type of harassment. So not just sexual harassment, it's anyone. So clients, customers, people who come to your restaurant, things like that, harassing your staff. And that is harassment for employment law purposes, is sort of treating them less favorably on the ground of a protected characteristic. So things like race, sex, disability, that kind of thing. So it really opens that up to be a really, really onerous duty on employers. So all reasonable steps to prevent sexual harassment, and that third parties must be prevented from sexually harassing your staff or committing any other type of harassment against them. That's going to need a lot of consultation to be able to get that into shape so that it's clear what employers have to do, and also how they're going to do that from an external point of view. You're going to put it in terms and conditions of business that the people we do business with, you must not sexually harass our staff, or how's that going to work in practice? I think it's a big change.
Yeah, I guess it's sad to me that we even need to do that. Do you know what I mean? Like, you just hope that people outside in the world who are adults and sensible wouldn't be trying to harass people in any way, shape, or form. So I'm sad that does happen and people experience it. But then I'm happy that the government are recognising these things happen and putting in stronger sanctions, because it sends a message, right?
Yeah, absolutely. I think that, you will have seen it as well. People often say, oh, things like that don't happen anymore. You think about what happened in workplaces maybe in the 70s and the kind of things that were deemed to be acceptable then. Yes, that kind of thing doesn't happen every day in the workplace now, but there's still some pretty bad stuff that does go on. And so, I think perhaps legislating is the only way to make clear what is and is not acceptable at work. But I know that, some organisations that have been doing sexual harassment training of their staff in preparation for these things coming in. I've heard all kinds of things coming back from employees who say, oh, well, we're not allowed to socialise outside of work anymore, or we're not allowed to, compliment someone on their appearance and say, that's a nice dress, you look nice today, because, and that's where it becomes problematic, I think, because people are scared about what they can and can't say. And so perhaps having some more clarity around what is and is not acceptable will be helpful in those situations, because I think otherwise it runs a risk of kind of the culture of an organisation sort of changing and becoming so sterile because no one wants to say anything to each other. So it's really difficult to get the balance right. But another potentially huge change.
Alrighty. Now, last but not least, drum roll, please. The Fair Work Agency. So the bill seems to hint, or not even hint, actually, it seems quite specific about it. It starts to talk about this agency coming in to kind of govern the world of work. What is this? And how's that actually going to impact people?
Well, yeah, I mean, I don't think they've been completely clear about it. When I first read it, I thought, oh, is this going to be like what we're going to call the Employment Tribunal now? Is that going to be kind of the body that deals with claims? Or and I don't think it is that. I think it is intended to be kind of a bigger step towards the state enforcing employment rights. And there's kind of limited availability for that at the moment. Really, all that gets enforced is minimum wage. If someone's not paying the minimum wage, then that's investigated by the government. People are named and shamed and given fines and all the rest of it. But for most other employment rights, it's reliant on an individual standing up and saying, that's not right, I'm going to take you to an employment tribunal, and the employment tribunal make the decision about it. So I think the intention behind the Fair Work Agency is going to be to give them more powers to investigate breaches of employment legislation and to take action in respect of it, rather than rely on the employee having to enforce those rights themselves, which, that should be no problem for employers who adhere to the law, which most people do. But for those unscrupulous ones, it's a way of really kind of cracking down on things in the same ways you see, I guess, from like immigration point of view, for people who haven't done the right to work checks, or who are involved in breaches of the slavery legislation and things like that. So growing on those existing enforcement rights, but all of these things are going to need a budget, right? And so, I think it remains to be seen quite how extensive that will be. Presumably, there will then be fines and things like that introduced in order to pay for that agency to be in place. But it's a brand new body, and potentially could have huge impacts, but not entirely sure how extensive that will be, at least initially.
I don't know why, but if anyone else who's listening / watching is a fan of Marvel and likes the Loki series where they've got the TVA, for some reason it just felt like they're introducing the TVA, and that's what I got in my mind. I'm sure it's not going to be that because I live in the Marvel series, but that's what it kind of conjured images of for me. As always, thank you so much for your time. I really appreciate it. And I can't emphasize enough how helpful that ability you've got to make things that are really difficult simple is. So I really appreciate you giving us the time and your energy and your light. So thank you so much.
No problem. Thanks for having me. It's always a pleasure to chat through employment law with you.
Fabulous. And if people want to get hold of you, what's the best way for them to grab a slice of your expertise?
Drop me an email, give me a call, or connect with me on LinkedIn. I'm always open to any of those.
And for any of you who are regular listeners, you know that we also post onto YouTube. So if you want to see the visuals and see our lovely faces, feel free to jump onto the YouTube channel. But also, if you listen to podcasts, you should be able to get them on any of your normal channels. So fabulous. Thanks so much for your time. And I'm sure I'll see you again soon. I'm literally just waiting for employment law changes to come along. So as soon as there's something else, I'll be straight onto my emails to see if we can have a chat.
Absolutely. Anytime.